Hey everybody, welcome to the Bold Patent Show. I'm JD Hoovener and I'm with Matt Colseth, and we're here hosting every week. Matt, we're doing it again.
I love it.
The Bold Patent Show. Thank you for joining me. You were out last week. Welcome back.
Thank you very much. Yeah, I was out hiking around Montana with a stick in my hand, trying to catch an elk.
I thought you were in Idaho.
Sorry, did I say Iowa? I'm in Idaho.
Okay, you said Montana. Where were you really? Okay.
Well, I was in Idaho. I was right next to Montana. But
okay.
Yeah,
Nice.
It was a ton of fun. We had a blast, and
good.
Mostly a camping expedition, but it was really exciting.
Awesome, man. Well, I'm jealous. You get to totally unplug and just get away.
Yeah, I got to come home to like 500 emails though. So I literally last night at like 10 o'clock and I just finished getting through all my emails. So
man. Well, I'm glad you made it out. I'm glad you made it here. Thanks for coming on. So we've got a cool show today. We're going to be talking about patents and trademark monetization, which is making money. And that's probably the reason why you would get a trademark or a patent, right? To make money, to be in business. And so why not talk about it? And so that is coming up on our show. We've got one live viewer. Good to see you. We will hope to welcome more. We're here every week, 1:30 Pacific and 4:30 on your East Coast. If you missed us live, catch us next week. We're here every Wednesday religiously. And I'm wearing a hat today. I want to make a quick mention of my alumni, University of Washington Huskies, hell of a football game last Saturday. We beat Michigan State. The hat hasn't come out before, so you can call me fair weather. But
I didn't hear that you guys beat Michigan State.
Oh yeah. We're ranked and we're super stoked. We're hosting Stanford. We're going to beat the tree this Saturday at home. Celeste, good to see you.
Hey, Celeste in South Africa. Super cool. I lived there for almost a year after college, before law school. Lived in Graaff-Reinet in the Karoo.
Okay, that is cool factoid. Well, welcome, Celeste. Please feel free to ask any questions you've got, or anybody you might be with. We'll take those as priority as we go through the program today. I've got a really cool bold bite today, and it's a literal bite. It's a food innovation, and also football related. Unbelievable. So it's an ex-football NFL star who's the founder. So that'll be cool to look at. I want to post a quick link here for anybody that is new or wants to take action from this meeting. If you feel like now is the time, you've got a question or two about patents or trademarks, click that weekly live link. That's your ticket to a free screening session and a copy of the book right there, Bold Ideas, The Inventor's Guide to Patents. It's an awesome tutorial. You'll get a PDF download right in your email and learning all about what's going on. And so you can ask the smart questions of Matt or I. Okay, so that's your link. I've got a couple Avil questions as well. We've got 3 Avil questions. I know we've been reluctant to get to those, but I want to make sure we try to get to them, Matt. One on trademarks, one on trademark infringement as well.
Sounds good.
Okay, so I'm going to, if you don't mind, I'll put you on the spot a little bit on trademark monetization. When it comes to monetization, I kind of use that word, but it just, walk us through what goes through your mind. If a client of yours asked that question, maybe they've gotten to the point where they've secured the registration and they're looking to make money. What are you thinking about? How are you advising the client?
Yeah, I mean, obviously there's a lot of reasons why you want a federal trademark registration. I mean, when we talk about monetization, that means exclusive use, right? So just being the only person, the only company that can use that name for that product or that service or anything similar to it. It means licensing, and eventually at some point it means the sale of the business, right? That's typically what it is. And at the end of the day, when we're talking monetization, a trademark can be worth a lot of money. We often don't think of a trademark in terms of a dollar value, but it's true that there is a dollar value associated to a brand, right? If you go look at the books of any major corporation or even some medium, smaller businesses, if they're wealth advisors or their CPAs are kind of more into that knowledge, you'll actually see like an line item for the wealth of the trademark, what it's worth. Right. And the simple way that you can do it on a big level is if you add up all the shares and the values of those shares, subtract the assets and the liabilities of the company, you're left with typically an enormous amount of money. And that enormous amount of money is the goodwill of the brand, which is represented by the federal trademark registration for it. So
Yeah.
worth protecting. And obviously, when you sell the business, that's what most folks want, along with the assets of the business as well. But brand.
Yeah, no, that's huge. I mean, so you're saying that, the goodwill, the business is the brand, right? If you
Correct.
take away the brand, nobody knows who you are, where to find you. All your sales stop. Maybe you've got this like office full of employees, but right, that's kind of what you're saying is it just would sit there in a vacuum without the brand.
Right. Right, exactly. How would people find you? How would they know you? If you've been in business 10, 15, 20, 30, 50 years, right? People know you, right? They've seen your signs, they've seen your advertisements. Maybe your dad or mom used them in the past, right? You're aware of that brand. And if they go and change their name, well, is it the same company to you? Is it the same quality of services or products? I don't know, maybe not. But when you have that name recognition and you go sell it to somebody and they continue carrying it on, that's worth something. And quite frankly, it can be worth quite a lot of money.
Yes, yes. Okay, let's talk about the kind of the defensive side of, making money, if you will, and, creating the elbow room. Let's say you see, you've been in business for, like you said, 10 to 20 years, you've established yourself in the market, and you see some new entrants that are kind of creeping, getting close to, and in your mind, confusingly similar with some of your clients.
Sure.
What actions can you take? Can you be the good guy in
Yeah.
any way or gal, and
Yep.
yet still enforce and monetize?
Yeah. So, I mean, the adage, like, if you don't use it, you lose it, kind of applies to trademarks. It's an adversarial process to get a trademark registration through the USPTO, the federal agency in charge of trademarks and patents. But once you have it, it's up to you to enforce the trademark against third parties who might be infringing your trademark. So it's a self-help world. Um, if you don't enforce your trademark against third parties, eventually they start to encroach on your brand. And at some point, they kind of inherit some rights to your brand, and you lose the ability to protect or enforce those aspects of the rights. So let's just say, for example, you're in business, bold patents, and someone comes
That
along.
happened to me. Sure.
Yeah,
Go ahead.
just so happens you call yourself bold patents,
Very good.
and somebody comes along and calls themselves bold patent, or let's
Right.
call it strong patents,
Yeah.
or bright patents, or even something similar to that. If you don't choose to enforce your trademark and say you know about them, but don't do anything about it for a few years, maybe 5 years, and then send a cease and desist, they can claim basically that they already own that brand because you've known about them and haven't chosen to do anything, and basically led them to believe that it's okay to continue using that brand. So
Right.
it's important that when you find something that you feel uncomfortable with in terms of this might be a problem for my brand, you just reach out to your trademark attorney and get their 2 cents. It won't cost you anything, or at least it shouldn't.
Very good. All right, we got a question here from Celeste out of South Africa. I understand that you're patent attorneys, but does an inventor always need to patent their work in order to license?
It's a great
Cool.
question, JD. What do you think?
Like it, and I'm gonna ask you the same thing on the trademark side, Matt, later. Okay, fundamentally, as I was trained and know the law, in order to structure a contract around an asset to license it, yes, you do have to have that asset. You have to own it, and so yes, you would have to have a patent in order to license something. I believe there are agreements for transferring know-how. Okay, and know-how or knowledge without actually having an asset. But it's not a license, right? There's nothing to license. A license is a very specific type of legal document that articulates what specific type of asset is being given, under what time period, what are the catches, right? What are the repercussions for termination and enforcement of that license? So, long story short, yes, you would need a patent to license something. There are contracts, lots of different types of contracts where you can transfer, sell in information and knowledge without actually having a patent. So I have heard of that. And so Matt, same question on the trademark side. Any nuance there?
Yeah, exactly right. I would agree with you 100%. It applies very much the same to the trademark side. You can license a brand that you own to somebody else to, produce products and sell on your behalf. That's a straight licensing agreement.
Yep.
If you are interested in franchising your business as a franchisor, you will need to have your clients or your franchisees, who are basically your customers at that point. You'll basically need them to sign, or read and approve a franchise disclosure document, which makes clear that you as the franchisor own federal trademark applications or registrations for the brand that you purport to give to the franchisee. So yeah.
Perfect. Good. Hopefully answered your question, Celeste. Matt, I agree with that. And Flavio, you're very welcome, as always. I want to talk patents real quick. And if you missed it, scroll up and get that link for the weekly live. You get your copy of Bold Ideas and Inventor's Guide to Patents. And I'm going to zoom in as best I can. Chapter 18, monetize your patent. Okay, so take a look. You get a copy of this. You'll learn how to do it in much more detail. But a lot of the same things that Matt said about trademarks is true for patents. When you're looking to secure your rights and make money with it, you can, one, like I said, right, enforce those rights, right? Do not sit on your rights, actively enforce against infringers. B, own that exclusivity, that limited exclusivity on the patent side. You're allowed to be the only one to make, use, and sell that product in the jurisdiction for between 14 years on a design patent or 20 years on a utility patent. And the other way to go is licensing. And what's cool about patents, now I'm not sure if trademarks really has this kind of nuance, but with patents, you can actually split it up really specifically, right? Each of those rights to make, use, sell, and import, you can split those up and say, I want to have this manufacturer be the only manufacturer that can make this patented product for me in the United States. But I'm going to be the only person to sell or to import, right? Or to use it. Or you can have some people have just be the retailers, have non-exclusive licenses to retailers, a set of 5 to 10, whatever national retailers, and no one else. And so you're allowing, just that ability to sell it, but they can't make it, they can't use it, and they can't import it. So you can kind of slice those different rights up and provide different mechanisms to make money with patents through licensing. And so, like I said, with Celeste's question about licensing, it does require a very specific, structured, right? What type of asset, how long, who's doing it. One of the tricky things about licenses is if they're only as good as you do a good job enforcing them. We, for example, have a license in place with another law firm with a similar name in a different state, and if we don't check on them to make sure that they're abiding by the rules of that contract, the 4 corners of that contract, it's no good. Okay, so it takes enforcement, it takes maintenance and upkeep to make sure that's in play. So all that should be considered before you enter into an agreement like that. Let's see, Flavio, we've heard of pro bono lawyers. JD, ever heard of a patent attorney?
I think he's asking about, are there pro bono patent attorneys, or do patent attorneys potentially get paid out if the product is successful down the road?
Oh, okay, I see. Well, we don't do that here at Bold. We have not done that. Why don't I do that? I think it's important to make sure our attorneys get paid. Okay. And I want to make sure that the attorney and the inventor understands each step of the process, doesn't get in a way confused or misinterprets the expectations for down the road. And so I really like taking it step by step with the inventor, and we break it down into flat fees, walk them through their options, make sure they fully are into investing along the way. If they do all the upfront investment for the client, they don't have enough skin in the game along the way. And I found that with our inventions, the best patents get done when the inventor's right there along with us and helping us draft and argue and get the best arguments, the best amendments, and the most invention through. So that's just our philosophy. There are different that do similar. Yeah, go ahead, Matt.
Yeah, I agree with that. It also there's a potential conflict of interest too if the attorneys take a stake in the business. Are we representing ourselves then, or are we representing the business, right? And so it gets kind of murky, and so a lot of firms will shy away from that sort of arrangement, however lucrative it might be for the attorneys. To your question about are there pro bono attorneys out there that do what we do? I would say no, not that I'm aware of, at least. But when I was a law school student, 14 years ago or whatever. The law school that I went to had a pro bono trademark intellectual property clinic. And you could potentially, get on the list for something like that, but it's hard to, there's a lot of people that want to get on that kind of list, and it might take a long time to get it. And your results may vary.
Absolutely. Well, let's get real. Your results are going to stink. You're not going to get, you're not going to get quality legal services in most cases. I'm just going to say it. Here's a link. I just posted it. I'm going to share it. I do want you to visit this website if you're considering getting pro bono services. The USPTO is an awesome website. Patent pro bono program. This is serious business. They have,
that's cool. I never knew that.
Every single state has and the University of Washington, I'm wearing the hat. I love this coming full circle, actually sponsors it. And so you can leave the USPTO and go to the UW, go UW. Patent pro bono program. Bold happens to be a participant in here. We're not as active as I want to be, but a lot of law firms will sign up to this. Generally, the bigger law firms. Okay, and do you think they're going to put their top partners on these cases?
No, it's the junior.
Actually not. You might be an intern, and you might get it done about 6 to 9 months after you want it done. So be careful. You get what you pay for. Bottom line. We had a live question that come in from Celeste. So she's following up, but it takes so long to get a patent, given it will come through at all. What if by waiting, you lose your chance of making money because the trend is past? Hypothetical, I know, but I love it. So Celeste, one thing to think about is you can do licensing deals before the patent is granted. And it happens from time to time where you get a patent application as the underlying asset that's being licensed. So if you've got a strong enough of application, and certainly if you've worked for the law firm, reputable, that has done a decent patent search and can give you a legal opinion, the investor behind that purchase or the company that's making the licensee, right, that's wanting to take an ownership interest in your patent, will do the research, maybe look up the attorney or the application, and they may be willing to make you an offer while it's pending. So yeah, patents can take a while, but you can still get a deal done. All right, Sean, I love these live questions. I have a few things I want to patent myself through my LLC. Absolutely. I like it. And one of the major reasons why we would do that, we had a few guests on over the past month or two, business attorneys. And I love their kind of, what their main point here would be is to allow the company to own the patent asset. Does two major things. One, it takes the individual, the inventor, it reduces their liability. Okay. So if that product gets sold, someone gets hurt, makes a claim for suit against the inventor, well, they're not going to be able to go after the inventor because it wasn't the inventor, the individual that was selling the product, it was the company. So the company's LLC does its job by limiting liabilities for the individual. Two, it will be able to transact much easier. And we just talked about licensing. A company, a franchise is able to do business way easier when they're conducting B2B versus an individual that has all kinds of state-specific rules or community property confusion. A business does business better with another business. Matt, would you add anything to that?
No, I wouldn't. Like a lot of times we've seen agreements with between B2B with parties, but there's going to be a personal guarantee too. That sits behind the agreement between business to business. But yeah, no, if you're in business to make money, or even as a nonprofit, you need to have a legal organization, some sort of legal entity, whether it's an LLC, a corporation,
right,
or a nonprofit 501c3. Like,
all right,
it's not much money. Just do it. It'll save you a lot of headache.
Absolutely. You're welcome, Flavio. And it looks like the examiner will grant you utility patent only if the language is how they'll want it. Well, yeah, that's going to depend on every attorney. Every attorney has their own style, and that's it for a good reason. Sean, you're welcome. Okay, let's go to our bold bite. Bold bite. You're going to love this one. I like ribs. Matt, do you like ribs?
Love ribs.
Okay, we're going to talk about Bubba's Q. This is his website. He and his wife did a really cool pitch here just about a month ago in August. So let's take a peek here.
JD?
Yes?
Sorry, I can't see your screen.
Thank you, thank you, thank you.
But the music.
I'm really loving this. I'm enjoying it.
Music making me very excited.
All right, he's coming. Here's Bubba. Let's back just a little bit. Let's get a little bit of that walk up. Okay.
Hi, I'm Al Bubba Baker from Avon, Ohio, owner of the D-Bone Baby Back Rib Steaks. I'm seeking $300,000 in exchange for 15% equity in my company. And this is my lovely daughter, Brittany. She's gonna make you sharks, ribs, in a microwave in 2 minutes. Now, I played a little football in the NFL for 13 years. That was my job. Barbecue is my passion. Sadly, I married a woman that doesn't like ribs because they're too messy. So I vowed to find a way for my wife to be able to enjoy ribs. But how do you make ribs less messy? You take the bones out. After 20 years, I found the perfect method, and the D-Bone Baby Back Rib Steaks were born. We are the only people that have removed the bones from an actual slab of rib, leaving the meat intact so that everyone can enjoy ribs with a knife and fork. Our D-Bone Baby Back Rib Steak is not pieces of meat formed in the shape of a rib. You know what I mean?
You tell, Bubba.
Boneless meats are the way of the future, and the future is now. Make no bones about it, sharks. It's time for some ribs.
Yeah. Always time
All right,
for ribs.
Bubba, bless me with the Bubba, baby.
Bubba, who'd you play for?
Well, I played for the Lions. I was Rookie of the Year in 1978. I played for the then St. Louis Cardinals, and then I came back and I retired in Cleveland in 1990.
That's a long career, man.
Great career.
This is absolutely delicious.
That's very
This
good.
is really, really good.
Thank you. Thank you.
So basically, I just want to be really, really clear. I buy this, I throw it in the microwave for 2 minutes.
And it tastes like this?
You got it.
Often when we go to restaurants, cowboy ribeye, bone-in ribeye, some people actually believe that the bone just tastes better.
That's a great point. We cook the product with the bone in it, and when the product is fully cooked, then we remove the bones, then we quick chill it, and then it's packed right away.
Is there anything proprietary about how you're removing the bone, or you're genetically altering cows so they grow up with no?
Actually, it's pigs. Kevin, it's hogs.
Okay, so why couldn't I just do the same thing?
Well, I'm not running, guys. It's not that much
Don't run
friction
through the
yet.
tough questions.
Okay, I'm not going to run through many questions.
Literally.
Right here, Kevin, is the patent for the product. And right here is the patent for the process.
Wow. Can I see the process patent?
Here, take them both.
So nobody else can make boneless ribs?
Let me be more specific. No one else can make a fully cooked rib with either one or more bones removed from it.
Wow.
And how do you get the bones out?
If I tell you that, I gotta kill you.
Kill them.
No, you don't. You got a patent. You got a patent for it, Bubba. You can tell him.
Yeah, tell me.
Robert, honestly, there's the patent, then there's the know-how. And what I say to people who are gonna go try and reverse engineer and figure out how to do it, I say, good luck to you, because it took me 20 years to do it.
I gotta tell you something. In the entire history of Shark Tank, I've never seen a patent on a food product ever before.
Thank you, because we worked it.
All right.
Ooh.
What do you think, Matt? Did you think that was possible to get a patent on a food like that?
I am highly suspect of his claims for that patent. I'm not a patent attorney. I don't think he's got a trademark. We can talk about that later, though. But tell me about the patent.
I did. I pulled it up. I was very suspect. I was blown away with how solid the patent is. Okay.
Really?
Yes, it is actually better than I thought. Okay, share screen again. We're going to go to his patent. I love critiquing patents. So this was issued June 2011. 7959500. This is a utility patent for the process. James A. Baker from Avon, Ohio. He wasn't joking. Filed it in 2010, so he's going to have exclusivity for 20 years from the filing date, so to 2030. Look at this utility claim. Okay. I was expecting it to be the length of the page, but it's not. It's short. A short claim tells you it is likely worth more. A process for preparing a length of deboned rib meat, comprising cooking a length of rib meat, having one rib bone at least partially embedded therein at a temperature and for a time sufficient to enable the removal of at least one said rib bone, while maintaining a substantially intact length of rib meat and removing at least one of those ribs. That's it. He really does have a patent on a process for cooking ribs and removing the rib. Incredible. And on top of that, he's got this. He's selling $5 million a year from his website. So crushing it. $50 for a full rack of ribs. I bet this did really well during COVID. I had never heard of it, but it's incredible. Incredible. Very, very interesting. But one of the things I wanted to focus on when I looked at that was that he mentioned, if you caught that, he's got the patent and then the know-how. Okay.
Yeah.
That can be problematic for Mr. Bubba. Okay. So technically, when you work on a patent, you're supposed to put the best method, meaning you have to disclose how it's done. But he's right that you can, in a way, not disclose other ways that it could be done. So it's kind of a very fine line that he's walked here. And it could come back to bite him in later litigation. In the patent law, the way it's written is you're supposed to put what's called the best mode, meaning the best known way to make it. And what he just told the public and everyone is that there's a better way. He has trade secrets on top of the patent, right? It's not just cook or slab a rib, pull the rib out. I bet there's tools. I bet there's certain temperatures. I bet it maybe comes up in temperature, then comes down, right? All sorts of different things to get it to taste just right. So it's really interesting, this sort of layering of patents with trade secrets. I think it's cool, but I wanted to point out the fact that it could come up in litigation if an infringer were to argue that his patent is invalid because he didn't disclose the best mode, the way to make the rib happen, or the rib make in the best way. But I think he may have some great arguments back, saying, "Look, I'm saying exactly how to do it. I'm just not telling you how to make it taste really good." Okay, so there's interesting ways to retain a trade secret, and as many people may know or may not know, a trade secret can be held for indefinite time periods, right? Coca-Cola, KFC, some of these really well-known food recipes and methods, you can retain that. There's no exclusivity period, right? There's no end date to having a trade secret. So I thought that was well done. Very impressive presentation too. Any comments on the trademark side real quick before we wrap up?
Terrible name.
Why is it bad?
I could tell you that the name was going to be taken, registered before, he opened his mouth, right? So, I mean, he obviously went to market with a product in a name before he probably consulted an attorney, because any trademark attorney would have told him that the name's already been taken, it's been registered, in every class in the United States, basically, and there's no way he can own that.
Right.
So just looking at it really quickly, it looks like he actually does not have a trademark registration or an application.
Okay.
So they must either be waiting for something to change, or they're just going to run without the trademark. Not a great solution, but you kind of, you play that when you're dealt, I guess.
Right. Yeah. I mean, it's one of those things, it's, and I think I last saw that they had closed their restaurant in 2019, but they're still doing online sales. But it's one of those things that when it's just a product, perhaps you can kind of get away with it for a little while, but eventually you're going to need to find a brand to sit on. So something you need to get that shored up. So cool. Thanks for that critique, Matt. Awesome. Well, guys, we're at the end of our show. Half hour's up. Matt, thank you for coming on, for talking monetization. Of
course.
And we'll be back next week. For those of you who missed us, we'll be here at 1:30 Pacific, 4:30 on Eastern time. Have a good rest of your week, guys. Take care. For Matt and I, from Bold Patents, go big, go bold.